Good morning. This is Ted Murmagos, Division Director here in the state of Delaware at the Division of Child Support Services. And this is the first Monday of the month. So we are holding our monthly Child Support Connection. And this gives individuals an opportunity to ask child support questions here at Child Support in Delaware. And it would also give people an opportunity, if you just have general questions about the Department of Health and Social Services, of which Child Support is a division of, I'd be more than happy to try and answer those questions or get you in contact with someone who may be able to help you here within our department. Also, if you have questions about, in general, about questions in state government, I'd like to try to help you answer those questions, but I like to consider myself knowledgeable, extremely knowledgeable on child support in the first state. So I want to be able to answer your questions about child support. So feel free to put a question in the chat section, and we'll go ahead and try to answer them the best that we can. So before we do those types of things, I just wanted to talk a little bit about paternity establishment. And I know I talk about this a lot, but it's really important to make sure that children who are born in the first state have paternity established. And it's also important for us here at the Child Support Program, because that's one of the most important things that we do, that the federal government, our Federal Office of Child Support Enforcement, holds us responsible for, is to work with moms and dads here in Delaware to make sure that paternity is established for children born in Delaware. Child support programs all around the country, we're all responsible for making sure that children who are born in Delaware have paternity established. So what I'd like to just go through real simple, there's 3 ways in Delaware that paternity can be established. The first is by marriage. So if the custodial parent and the non-custodial parent are married at the time the child is born, paternity is automatically established for that child. And the Office of Vital Statistics will update the child's birth certificate with both the mother's name and the father's name because of the fact that they were married at the time the child was born. The second way that we establish paternity here in the state of Delaware is through the Voluntary Acknowledgement of Paternity program. And that's a program that we operate here at the Child Support Office. And it's a very simple and free process to make sure that paternity is established for your child. And that's by asking for a voluntary acknowledgement of a paternity form that we can send you. And the form basically gets completed by both the custodial and non-custodial parent and is notarized and submitted to the Office of Vital Statistics. And they will update the child's birth certificate with both the mother's name and the father's name. The key thing about the voluntary acknowledgement of paternity form or program is the word voluntary. And it is for both custodial and non-custodial parents to complete when they are without a doubt sure that I am the biological mother, I'm the biological father, and I'm going to fill this form out and have it filed with the Office of Vital Statistics. Any state office will notarize that document for free. We will notarize that document at the Child Support Office for free, and we will help people complete that form for free here at Child Support. And then the third way that paternity is established is through genetic testing. And back in the day, we're talking 10, 15 years ago, they would draw blood and have those samples sent off to a lab to determine genetics. We don't do that anymore. It's done with a swab of the cheek of the mom, the child, and the putative father. And those test samples are sent to a lab and are quickly returned to the parents that says this person is or is not the biological parent based on a certain percentage. If it's 99% or higher, That usually means you are the biological parent of that child, and the family court will adjudicate that paternity based on those test results, and will ask the Office of Vital Statistics to update the birth certificate based on genetic testing results that have been done. We can help you here at the Child Support Office to schedule those appointments, but it's so important that paternity gets established for children, and I want to make sure that the benefits, like I mentioned, to the program, we want to help people do that, but the benefits to the child are so important because first and foremost, emotionally, that child will get a true understanding of who their mom is, of who their dad is, and that goes a long way with emotionally supporting that child when they know that, hey, this is my dad, and genetic test results have proven that, or whatever. Benefits from the Social Security Administration. When someone passes away, those benefits may be afforded to children of the deceased party, but you've got to have genetic testing, or you've got to have the paternity determined and updated, birth certificates updated. Knowing medical history. As a child, my dad had heart problems or had diabetes, and I'm susceptible to those same types of medical conditions. So knowing medical histories are so important of determining and having a sense of who the biological parents are. So I wanted to make sure I just kind of talked about paternity establishment. If you need help, have questions about paternity establishment, call the Child Support Office. I'm going to give you our customer service number. That's the second bit of important information that I need to share with people. Customer service here at Child Support, 302-577-7171. And one of the things I wanted to mention real quick about our customer service unit. If you call customer service, sometimes we hear in the director's office, I called customer service and I was on hold for an hour, I was on hold for 2 hours. Please, please, please share this with anybody you know that has a child support case. Do not ever wait on hold for over 20 minutes. If you're on hold for over 20 minutes, there's a problem and you should hang up and call back. Do not wait on hold for any exorbitant amount of time. Our people are answering your telephone calls from 8 to 4, Monday through Friday. I see that we've got some questions, so I want to go ahead and make sure we get some of those questions answered. The non-custodial parent filed for bankruptcy last year. I filed a claim during his bankruptcy for the arrears with the bankruptcy court. Since child support is supposed to be considered a priority debt, somehow I was not notified of the court hearing via mail and the claim was dismissed. If Chapter 13 bankruptcy is filed, I thought the obligation must be paid as part of the repayment plan in order for the debts to be discharged. Why can't DCSS follow up with this issue and work with the bankruptcy trustee to pay down the arrears? When I notified the caseworker of the bankruptcy, she stated child support was aware of the bankruptcy was filed. However, the explanation on what could happen next was vague. Child support granted $77.59 a month, and in addition, 60 a month on the arrears. I rarely received the whole amount, $15,000 in arrears. In addition, the income, he has income not reported and cannot be taken from a wage garnishment. He rents homes, LLC, and works under the table. Okay, so bankruptcies. Chapters 13 and Chapter 7s, we received notice from bankruptcy attorneys and representatives that non-custodial parents may have filed or have filed bankruptcy. This subject is, as you probably suspect from that question, is very complicated for us here at the Child Support Office. And we have tools within our child support system that helps us update the case record when someone has filed bankruptcy. And certain actions can be taken, and certain actions, when someone files for bankruptcies, we have to stop taking certain actions. One of the things that I can tell you we should be doing, is consulting with the Department of Justice. on any bankruptcy case, specifically a bankruptcy filing of a Chapter 13, to make sure that we're notifying the bankruptcy courts that there is a debt owed for child support. So when in this question, I certainly would like to take a closer look at and make sure that we've looped in the Department of Justice, and they have attorneys that can help us with these bankruptcy issues. So there may have been, and I'm certainly, if you paid attention to any of these Child Support Connection videos before, if we've messed up, I certainly want to address that issue. Bankruptcies, Chapter 13s, they are complicated, and we should be, in those cases, consulting with the Department of Justice. And I probably, and some of my leadership team, needs to work more closely with the child support specialist to help them understand the bankruptcy process. But we can certainly take a look at your particular case and make sure that if we've not reached out to the bankruptcy attorneys, that we try to do that if it's not too late, and reach out to the bankruptcy court to see if it's not too late to get looped in to make sure that we can get some arrears addressed. Now, the second piece of her question, or their question, it dealt with working under the table. We've talked a little bit about that in previous Child Support Connection events. Working under the table is extremely hard for us to enforce, and there's really limited enforcement tools such as wage withholdings and that kind of thing. Obviously, we can still intercept tax refunds if they're filing a tax form, and they're able to get a refund. We can certainly intercept that, and we still have the ability to work with the court by filing contempt petitions if someone is not making their payments and working under the table. If sometimes when a person is making partial payments, we would certainly consult with the Department of Justice and consider filing contempt petitions, but we would need a little bit more information. The child support specialist would have to examine the payment history and see if we can get some assistance with the Department of Justice to help us file a contempt petition. But those cases where people are working under the table, own their own businesses, and are working illegal activity to support themselves, those cases are extremely difficult for us to move forward. And move forward with. But contempt petitions or something of that nature. And one of the things, and I'm going to move on to the next question, but one of the things that I also have been working closely with our child support specialist on is to pick up the telephone, reach out to that non-custodial parent, and let's see about talking to them about their payment habits and what we can do to try to help them make more consistent and timely child support payments. The next question is, and it may be from a non-custodial parent, which is great. We want non-custodial parents to tune in. How do I get my child support lowered? I am not working right now due to the pandemic. My suggestion for anyone who had a child support order put in place based on employment history or based on place they were previously employed, like this gentleman, is to go to the family court. There are resource centers in each of the family courts in Newcastle, Kent, and Sussex County. Tell them that you are interested in filing a petition for a modification of your child support order. They will give you the documentation. Also, the family court's website has documents, petitions, motions that you can actually print online and actually fill out at home and then file directly with the family court. If your custodial parent is a client of the Division of Child Support, make sure that you write by their name, Child Support or DCSS, and then / and then their name in the filing, so the courts know to make sure we get a copy of that filing at family court. But you want to go to a resource center at the family court or go to the family court's website. You can get there through de.gov, and there's petitions for modifications of your child support order, and I would recommend that you do that. We don't want, and this is as a state agency, we provide a service to all Delawareans, and we don't want non-custodial parents to have a child support order that they can no longer afford. We want them to have affordable child support orders, and the best way to do that is to file that modification if you've lost your employment. And Kevin, one other thing, for those people who have lost their employment opportunities, we have the Delaware Fatherhood Program. It's a employment services based program that we have at Child Support, that we will hook you up with an employment and training vendor who can help you find employment opportunities here in the state of Delaware, even during a pandemic. So contact us at 577-7171 and ask to speak to a representative in our Delaware Fatherhood Program. Yep. Someone has already also replied to you in our chat section. The next question is, the child support is too slow. Filed a motion in October, had mediation on February 2nd, and got child support lowered. March 1st, and your department is still deducting more than I owe. So so in Delaware, if the family courts create a child support order, we get that order from the family court. We enter it into our child support system, and the system would automatically issue a new wage withholding to your employer. It's always good for people to, after a court hearing, to let us know, hey, I had a court hearing, my obligation got lowered, and I need a new wage withholding sent to my employer. We would also be willing to accept a copy of that court order from both parents, custodial or a non-custodial parent. They can fax those new court orders over to us, and we would go ahead and update based on the employer information. We would send a new wage withholding out. Ultimately, it does take time for us to get the information into our child support system, and then sending out a new wage withholding. And then once that employer gets the new wage withholding, then they have to set it up in their payroll processing system, and then those deductions will change from one amount to another amount. If there are arrears owed on your case, let me say this first. If we get a court order that retroactively modifies your child support, whether it's up or down, we will make those changes in our child support system effective the effective date of that court order. If there are arrears owed on the case, anything that came in over and above that new current support obligation would be credited against the arrears balance. And if there were no arrears balance owed, once that current support obligation was satisfied, payments could be returned to the non-custodial parent as a refund. But it's always important, and this is one of the things I always preach, it's always important to contact the child support office and let us know what's going on. You got a new order, call us, and let's get it in the system as quickly as we possibly can and get a new wage withholding sent to the employer as quickly as we possibly can. We certainly understand that people would like things to happen quicker. We try to be as efficient as we possibly can. We'd rather be efficient and a little bit slower than making errors and trying to get documents quickly put into the system. But don't forget too, we're getting a whole stack of orders from the family court at one time, and we're working hard to get those orders into the system as quickly as we can. Yep, and we'll go ahead and take a look. This is just some follow-up to the bankruptcy question we had. We'll make sure we look at the case and get with the Department of Justice to make sure that we can get some information from them. How much does an LLC have to make in order to have to file their taxes? Unfortunately, I don't know the answer to that question, and that's probably a question for a tax preparer. I'm not sure. The question is, how much does an LLC have to make in order to file taxes? Like I said, I'm not sure what the answer to that question is. I would suggest reaching out to a tax attorney if you really want to know the answer to that. Okay, so that's all of the questions that are currently in the chat, and So why don't we go ahead and just talk about a few other things right now? At child support, I always like to continue to remind people during the pandemic, we are scheduling people to come into the office for appointments on an appointment-only basis. And if you need to make an appointment or you think you need to come and talk to somebody at the child support office, we would ask that you first call customer service, and let's see if we can triage your particular question or concern to avoid you having to come in. There's no sense in coming in if we think we can answer the question in advance. So I always am recommending to people to call customer service at 577-7171. Let's hear what your question is, and then if they think you need to come in, they'll schedule you a time to come into our office and actually meet and talk to someone in our child support office. That way, we save you from having to come in and that kind of thing. So the other thing is we are obviously, as a state agency, we are following the coronavirus safety precautions, wearing a mask, social distancing, washing, making sure we're washing our hands. And we're certainly grateful for people who follow those rules, especially wearing a mask when you come to our child support offices. And we're encouraging people to do that. If you don't have a mask, we can give you one if you're scheduled to come in to our office. But we're asking people to make those appointments first. Our offices are open, but like I said, we're making sure that people call and schedule an appointment to come to our child support office. The second thing that I wanted to talk a little bit about is kind of the process of child support. So at child support, if you are receiving temporary assistance to needy families at our sister agency, the Division of Social Services, or you are getting or receiving Medicaid for your child, we automatically get a referral from the Division of Social Services, and we will create a child support case on your behalf and actually generate a petition for child support with the family court. If you're not receiving those benefits from DSS, you can go onto our website and actually complete a child support application electronically, or you can call our office and we will send you an application to fill out and return to us, and we will open a case on your behalf. For those people who have to submit an application, there is a $25 application fee, but that is a one-time fee that covers all of the services we provide here at the Child Support Office. If you've been on TANF or Medicaid and we get that referral from DSS, we do not charge a fee for opening and working a child support case. Additionally, if a child is in foster care, that is another way that we will automatically get a referral from the Division of Family Services, and we will automatically create a case here at the Child Support Office. But once we create that child support case, we have to verify the information that either came over from the Division of Social Services or the information that's in the child support application, to do our locate activities, locate that non-custodial parent, whether they're in Delaware or they reside in another state. And then we will go ahead and begin the process of getting a court order. Now, if the non-custodial parent resides in Delaware, or the child was conceived in Delaware, we will try to pursue that case in the state of Delaware first. And we will use the tools of generating a petition for child support, and we will file that or generate that document and send it to the Department of Justice. They will review that petition and file it with the family court, who will schedule a family court hearing. In Delaware, if there are no previous domestic violence issues, the hearing will occur at mediation, and a family court mediator will help the parties mediate a child support obligation. If at any times during the family court process the parties cannot come to an agreement, that case will be then referred up to a commissioner who will actually hold a child support hearing. At all mediations, a child support specialist will accompany the parties to a mediation. At a commissioner's hearing, the Department of Justice takes over and has a deputy attorneys general that will participate in the commissioner's hearing. The one thing that's important to know is you're going to receive notices from the family court to bring financial information with you. And I always tell both non-custodial parents and custodial parents, always bring the financial information to family court. That way, when they try to determine what the child support obligation is, they will have accurate financial information to generate the court order. Other issues that can be addressed at mediation are obviously paternity issues. No child support orders will be created in the state of Delaware without paternity being established. Before I go back to the questions, I want to just touch on one more thing. If the non-custodial parent resides in a different state and the child was not conceived in the state of Delaware, we will help the custodial parent from Delaware pursue a case in another jurisdiction, and we will use it using intergovernmental processes with the other state that the non-custodial parent lives in. There's a child support connection, just like the name of this video, child support connection with other child support agencies around the country, and we work closely with them to get orders created and to enforce those court orders. Okay, so let's go back to some questions. And I certainly appreciate these questions, and I'm encouraging people, if you know non-custodial parents, they too can participate and ask questions, and I encourage people to get non-custodial parents to participate. If applying for jobs and the other parent makes $120,000 a year, but is demanding money and making threats, what would be advised to do before mediation? Let me say this. We know here at the Child Support Program that child support can be a highly emotional and sensitive subject. One of the things we are always encouraging custodial and non-custodial parents to do is to work together for the best of the child, continue to try to work together in order to obtain an accurate child support order. In the long run, that will definitely benefit both parents and the children that are involved. But let's get to the core of this question too. You know, just because the custodial parent may make more than the non-custodial parent, you know, one of the things I always tell people is it's both parents' responsibilities to support that child financially. So it's important to, prior to family court, work together as much as you possibly can with the custodial parent. It's always beneficial, if you can, to make some kind of a payment working up to that family court hearing. My suggestion is always to the non-custodial parent, pay what you can afford to pay. Do the best you can to pay the custodial parent directly until that court hearing. But make sure you tell the court, hey, and save receipts, if you can get receipts from the custodial parent, save canceled checks or money order receipts on what you paid up until that court hearing as a history of the payments that you've made. And then the courts may be able to take that into account when they're creating a child support order. And they look to go back in time. You've got receipts of things you've paid. The courts will always establish an order based on the income of the parties. So if you're the non-custodial parent and you make less, they will take what your income is. That's why it's important to bring those financial documents with you to court so that the courts know, hey, this is what he makes or this is what she makes, and they will determine what that obligation will be. They use the child support calculation. So they're not just pulling numbers out of the air. They use a calculation, a formula, take both people's income, and it determines what the obligation would be for the non-custodial parent based on both parents' financial situations. So the best thing I could advise you is to bring in receipts, bring in your pay stubs, and you know, as a secondary question to this, he is mentioning that there is a 50-50, I'm assuming, custody verbal agreement. My recommendation is, in the state of Delaware, child support, custody, visitation, 3 separate issues. They'll certainly talk to you guys about, hey, what's your current custody situation? But my recommendation would be to go and get a custody order in writing from the family court. The one thing that non-custodial parents need to remember is that a non-custodial parent can file in the family court for child support if they want to file. If they hey, I'm the non-custodial parent, but I want to pay, and I want to pay the correct amount, I can file for child support to get a child support order. Happens all the time. You can file as a non-custodial parent for a custody order, a visitation order. And that puts both parties under a legal obligation to follow court-ordered custody, visitation, child support. If custodial parent doesn't follow the custody order, non-custodial parent can file a contempt petition because the custodial parent is not following the custody order. So, I mean, it goes both ways. One of the misconceptions by non-custodial parents is that it's only against me. That's not the way it works. And we encourage people to file court order, to get a court order for visitation, for custody, for child support. Waiting on custody is such. Is there such a thing as 2 years back support prior to filing? So in the state of Delaware, the courts have the discretion to determine when the start date would be, but in most cases, it's usually the date that child support order was filed with the family court. That is when usually the court child support order will start. So in some cases, we at Child Support file a petition for child support in the family court. If the courts cannot serve that non-custodial parent, non-custodial parents have to be personally served. And if that non-custodial parent cannot be personally served, then child support orders can go back until the date that petition was filed with the family court. Sometimes it could be years if we can't serve the non-custodial parent, but that's why it's advantageous. It's better for the non-custodial parent to accept service because the action has already started. The petition has been filed with the family court, and the clock is ticking. Get in there, get the order, and start paying so you're not accruing an arrears balance. Let's see here. So the courts will go effective the date of filing when they come to child support. And I'm glad to hear you're waiting on a custody hearing. So get that in writing. How come a capias means nothing to the law? The non-custodial parent had a capias for non-showing, non-payment for years. He pays for a little bit, then child support acts as though I need to do work to find the non-custodial parent. He doesn't give information. Let's see here. He doesn't give information. He's been picked up in New Jersey before, but they don't extradite to Delaware, from what I've been informed. Why is it that he has never served any time, but some others are missing payments and apprehended quickly? However, we are now at my child being a disabled adult, and there is all these arrears at the time since she's beyond the age of support. Shouldn't have to know a thing, y'all. I shouldn't have to know a thing you sent, but never follow up on requests for withholdings from potential employers either. Couple things. Capiases. So, in the state of Delaware, if a non-custodial parent does not show up for a court hearing, does not show up for genetic testing, the courts can issue a bench warrant for their arrest. In the state of Delaware, what usually happens is, and we don't, in Delaware, we do not really go and run stings, or work on, knocking on doors at 5:30 in the morning and start pulling people out of their beds and that kind of thing. We would rather work with non-custodial parents to gain their trust and then compliance with their child support orders. If the family court has issued a capias, it's a civil bench warrant, not a criminal bench warrant. What normally happens is when the non-custodial parent is picked up on a traffic violation, is pulled over for a traffic violation, commits another crime, a criminal act, the courts, the law enforcement agencies will then notice in the history that there is a family court capias and will include that in the issues that they're trying to resolve and have that capias canceled. So it's very, there are some rare situations where the law enforcement will help us by picking someone up where there is a family court capias. But, what happens is the process and the law enforcement being taken off of the highways and taken off of their normal, law enforcement activities to deal with a family court capias is sometimes, lower in the priority, making sure that, other activities are being resolved, criminal activities and that kind of thing. I'm not law enforcement, so I can't justify why the whole civil capias issue is lower on the totem pole, but we try to work with non-custodial parents to gain their compliance. If we know that someone is working somewhere, we normally try to verify that employment before we send a wage withholding. I've mentioned, before that the employer community is so important to the child support process that we try to verify employment of non-custodial parents before we go ahead and issue wage withholdings just willy-nilly, just sending them out all over the place. We want to make sure that the person is employed there and verify that information first. I'm sorry to hear that your daughter is disabled. The one thing about child support arrearages is those arrears stay on the books, and we will try to continue to collect those arrears as much as, until they're zero. The child, can be well over the age of emancipation, but we try really hard to work those cases to try and get those payments in the door. The one suggestion I would want to make to you is don't give up on collecting those arrears. A lot of times custodial parents come to us and say, I just want to give up on I want that whole case to go away. Don't give up on the child support case, especially if it's an arrears only case, because there's sometimes we get a hit. The non-custodial parent wants to sell a piece of property and there's a lien on that property for child support. Sometimes they file their taxes and they're going to get a refund and we can intercept those taxes. So we're asking that don't give up on those. Don't ever forgive child support arrears in full. We don't want to see custodial parents walk away from those arrears. We can certainly try and do things to collect on those arrears. But the family court cases are hard situations to deal with. We try to work with the law enforcement. And one of the things, let me talk about cases, one more thing, then I'll move on to the next question. If you know a non-custodial parent who has a capias, if you are a non-custodial parent with a capias, we are strongly encouraging you to turn yourself in at family court. And I've said this before, 9 times out of 10, you will not be, incarcerated. Probably 99.9% of the times, you will not be incarcerated. The courts will ask you to come back on another date to conclude that hearing that you missed. They're going to reschedule you a date for you to come into come into family court, have that hearing, and let's move forward with the child support situation. So don't ever fear going to family court to resolve a capias. If you have one, let's get it cleaned up. Let's get you back on track. I'm also encouraging non-custodial parents, make a payment. If you can start making regular payments to child support, that will help your situation. At time. I would not have issues with the capias not being enforced if something would have happened, but it's been 27 years. So let's try and do this. My thing is this. Why don't you call the child support office, call our customer service unit, and make sure that if you have information for the non-custodial parent, let's make sure we have that information too. And we can go ahead and verify the information, and let's try to move forward with finding a good address, finding out if we can find an employer, find out if we have a good phone number. We'll reach out to the non-custodial parent, and then take steps to move the case forward. That's the best thing that we can do under this situation. And I see my community relations officer is also answering some of your comments, so I think that's great. So let's talk a little bit more about some of the things we do at Child Support. We talked a little bit about mediation. Always important to bring your financial information to family court. You know, one of the things that's important is, let's talk about some of our enforcement activities. I talked a little bit already about our tax refund. We're starting to get into a situation where filing your taxes for the 2020 tax year, we at Child Support will certify child support arrears with the IRS and with the State of Delaware's Division of Revenue. If a non-custodial parent owes child support arrears, we basically send that information to the IRS and say, if this person files their taxes, that's the key. The person has to file their taxes and have to be due a refund from those taxes. And if they're going to get a refund but they owe child support arrears, we will intercept those arrears. We will intercept those refunds to pay off the child support obligation. If they get a tax refund from the state of Delaware, we will intercept that also. We also will report individuals who owe child support. We'll report them to the credit bureaus, so that if they try to buy a house or try to buy to get credit, it will come up on their credit report that they owe an outstanding child support debt. We also have a program where if someone is due to receive a lump sum payment because they've got a personal injury lawsuit or a workers' compensation claim, we can actually get intermittent payments from a workers' compensation claim from the insurance company, and we can also get a lump sum payment. But we have to file paperwork with the family court, or we would have to issue them a lien that says if this person is going to get a lump sum payment, check with the child support office, and we will go ahead and send you a family court document that says if they're due to receive a lump sum payment, we want you, insurance company, or we want you, private attorney, to know, hey, they owe outstanding child support, and we want to intercept that a lump sum payment to pay off those arrears, and we will do that. If a non-custodial parent has a relative who has recently passed away, and the non-custodial parent may be, and the key here is maybe getting us a lump sum payment from an estate. We would need to know that. Let us know, hey, non-custodial parent's mother passed away. She lived in Kent County. Here's her name. We will check with the Register of Wills to see if they're going to receive a lump sum payment from an estate, and we can intercept those lump sum payments to pay child support off. So that's another thing we do. We work, many people know about our license suspension program. So we have a license suspension program that we can suspend a driver's license. We can suspend a business license, a professional license, or a hunting and fishing license here in the state of Delaware. So if someone owes child support arrears of $3,500 or more, we automatically will send them a letter that says we're going to submit you to suspend your license to one of those licensing agencies, the Division of Motor Vehicle, DNREC, Division of Revenue, and we will notify them that we're going to suspend their license, and we give them a certain amount of time to call us and to make a lump sum payment on their child support case. If they make that lump sum payment, we will not suspend the license. So it's always important, if you're a non-custodial parent or if you know a non-custodial parent, if you get a letter from child support, don't ignore it. And we will go ahead and work with the non-custodial parent to avoid suspending a license. But it's going to require a lump sum payment of some kind. The normal process is 2 months of their child support payment. But we will work with non-custodial parents. If they come to us and say, hey, I'm working and here's my employer and I'm going to make a good faith lump sum payment, we will work with them to get them back on track and not suspend a license. Or we will work with them to unsuspend a license, but they have to contact us in order to do that. The license suspension program is a successful program here at Child Support. We try to work with them in order to get their license back to them, especially if they've got employment opportunities. So, that's, some of the things we do here at Child Support. We work with other child support agencies around the country to help us enforce those child support orders. And, it's a process. But, one of the previous inquiries talked about, child support requiring assistance from the other party, the custodial parent. We cannot accurately enforce child support orders here in Delaware without the help of custodial parents. It's so important for us. We need them to help us. We have tools that help us locate non-custodial parents, help us locate income. But it's, we really need custodial parents who are, living this every day and have communication or have contact with non-custodial parents to help us, to provide us information, to get us in the right direction. More than all of the electronic locate tools that we have, the custodial parent or family members or employers who work with non-custodial parents who are feeding us information. That's the most important tool that we have is in our arsenal of trying to helping to get non-custodial parents to get in compliance with their child support case. How long does it take a modification to go through the family court? We already did custody order, and we basically have a 60-40 split. I also filed an appeal to a commissioner's order because she ordered that my child support payments, she ordered that my child support payments to be very high off of the hazard pay that I was getting last year, which I do not get anymore. Okay, a couple things. So when a petition for modification is filed with the family court, it can actually take anywhere between 2, 3, 4, 5 months to get actually heard at the family court. Throw in a pandemic, it could take a little bit longer. The key to this is just like filing a new support petition, the courts will go from the date of filing. So it's important to get that filed, but the courts will go retroactive. So you will get credit. If the obligation goes down, the non-custodial parent will get credit for anything that was received over and above for current support that, while it was at a higher amount. And we will take it off of the arrears balance. If the obligation goes up, that's the thing about a modification. If someone files a modification, regardless if you're the custodial parent or the non-custodial parent, remember I talked about that child support formula. They put the information in the child support formula, child support calculation. Whatever the information comes out at the end, if it determines it's going to go up, that's the new obligation effective such and such a date. If it goes down, that is the obligation such and such a date. The use of that child support calculation keeps it straight. It keeps it without there being any subjective information being put into the calculation, and but it will automatically come up with a number, and it's effective the date of filing. Certainly, there can be deviations from that child support calculation, but both parties got to agree to that. So to answer the first question, it can take anywhere from 2 to 3, 4 months for a hearing to be held, but you should get retroactivity from the date of filing of that petition. Now, when you're talking about appealing a commissioner's order, That's filing for a review by a family court judge of the commissioner's order. That could actually take a little bit longer, but the family court judge will review the prior order, will review the child support calculation that was conducted, and will refer that back to the commissioner if there needs to be a change done, and the parties may have to come back into court, or the family court judge could say, nope, everything was followed correctly, and and issue a new order to the parties saying such. So it's up to the filing of the family court and how long it will actually take for a new for that modification hearing to be heard. That's why it's so important to get it filed in family court, because the courts will go back to that filing date. So I hope that helped answer your question, but it could take some time. That's why I can't reiterate this enough. It's so important. Keep your eye out for the family court mailings that may come to your home. Pay attention to information that you're getting from child support. Reach out to us. We want to help non-custodial parents understand the family court process just as much as we want to help custodial parents understand the family court process. And we will work with them directly in those situations. And one of the other things that I want to make sure people know is we are here to do this, the Child Support Connection, whether we have 50 people listening in, whether we have nobody listening, because this will be posted on our Facebook page. But we love the questions. So we are encouraging you, if you know somebody who has a question about child support, to tune in and ask it here. We want to help you. Call our customer service number, 302-577-7171, and we will help you by answering your questions that you have, calling our child support customer service unit. And we just got a question that's in Spanish, and unfortunately I don't know Spanish, but this brings me to a very important point. We have bilingual child support specialists in all three of our offices. We have bilingual child support specialists in our customer service unit who are answering questions from our bilingual community. So I feel free to call, and you can speak to someone who is bilingual at 577-7171. I wish I could interpret this the Spanish question, and Bob has answered. Bob, our community relations officer, fantastic. He has answered in Spanish. That's great news. Thank you for that. That's great. He has translated a response to our bilingual inquiry. So we're starting to get close to the end, and I just want to remind people again. If you have a specific case-related child support question, I can only encourage you to really call our customer service unit. They will help triage it. They may say to you, hey, look, fax that question, fax these documents, and we'll make sure it gets to the worker. The other important thing, if you go to our child support website and you go there through you can go to our child support website through Delaware.gov. Sorry, I lost my train of thought there. Go through Delaware.gov. Up in the corner, there's a menu bar, and it lists state agencies. Go to the state agency. Go to our child support website. There is information about our customer website. If you sign up for our customer website, non-custodial parents with a case number, custodial parents with a case number, go to our customer website, and you can actually sign up to actually have pieces of your child support case through our customer website. You can actually send a question to your worker through the customer website. You can print an account statement. Say you have a court hearing or a mediation session, and you want to have an account statement ready to go with you, you can print that from home. You can send questions to your worker through the customer website. You can check the status of your case through the customer website. Man, I can't encourage you enough. Sign up for the customer website, and you can get pieces of your child support case or speak to your worker directly through that website. It's a little bit cumbersome to sign up that first time because you have to go through the state's firewall. But after you do that, you create a username and password, and you can access pieces of your child support case through that customer website. I encourage you to do that and have information at your fingertips. If you have trouble logging in or trouble creating that access to your personal customer website, you can go through 577-7171, and there are people there to help you. It's the customer website. And Sean, you can get there through our child support website, our general child support website. There's information about how to get to that customer website on our division's page. We have on our Facebook page, our community relations officer took the time to make videos about a step-by-step video on how to sign up for our customer website. And that's on our Facebook page in our video section. I encourage people to check it out. You can actually have pieces to your child support case. I also want to talk real briefly, because I only have 4 minutes left, and then the next time, next month in April, I'm going to talk a little bit more about this new functionality that we're going to be introducing in late spring of 2021. And it's our proactive customer notification system. And the only way that I can describe this, it's similar to other communication tools that you may have access to. So similar to like the Christiana Cares of the world and the Bay Health of the world. They have a system where you can log into their portal, and it sends you a message. Hey, you got an email from child support. In your proactive customer notification system, you log into the system and you'll see emails from us or notifications from us that, hey, we haven't gotten a payment from you lately, or hey, you have a family court hearing coming up, Mr. Smith, on this date and this time. But people have to sign up, and we're going to be sending out a whole bunch of information in the late spring of 2021 about our proactive customer notification system. And we want people to learn more about that, and we're going to send out information about that, a welcome kit, welcome information about our proactive notification system. It's just one more tool that we have at Child Support that's going to be able to share information with our customers. And I can't wait till we roll this notification system out. And we want people to get text messages from us, emails from us about this proactive notification system, about when things are changing in your child support case, or when we have information we want to share with you. Hey, you have a child support hearing coming up at Family Court in Newcastle on this date, on this time. Or, hey, we haven't gotten a payment from you this month. Or, do you have employment information you want to share with us? And it's going to engage the custodial parent and the non-custodial parent in certain aspects of their child support case. We're going to be, I think, one of the first states to roll this out around the country, and we are so looking forward to it in the spring of 2021. So stay tuned for that. And I see that people have got information about our website in the chat section, so please, if you're going to be watching this video in a couple of days, or look into the chats of the questions that came in and the responses that we gave, and you'll find more information out about our customer website. So it's 12:29. I want to thank everyone for participating in the Child Support Connection for March of 2021, and stay tuned for the first Monday in April. We will be back to do the Child Support Connection. Thank you so much for participating. Thank you so much for the great questions. Encourage people that you know that have an interest. They may not even have a child support case here in the state of Delaware. If you're interested in learning more about child support, share this with other people you may want to know. You know, one of the things that's important for me to once this pandemic is over, I want to start reaching out to the high schools here in the state of Delaware. I want to start talking to those that are incarcerated here in the state of Delaware about child support. You know, we have information that we can share with people who are in high school about the benefits of not becoming a child support case here in the state of Delaware, about being smart, about not getting involved or having children out of wedlock, that kind of thing. So, you know, if you know somebody that can learn something from child support, we ask you to share this information about the Child Support Connection. The first Monday of every month, we're here, and we'll take questions from anybody about child support. So thank you again, and we encourage you to tune back in next month at 11:30 a.m., the first Monday of the month, and we will be back. And thank you for the great questions today. We're going to be signing off now, and we'll see you in April.